My name is Arpan Banerjee. I'm a doctoral fellow at the Department of East Asian Studies, University of Delhi, and academic counselor here at IGNOU. And I have been teaching you the paper Indian Government and Politics. The code of this paper is BPSC 132. And I welcome you all to today's lesson. So let us begin today's class. So far in this paper, we have done block 1, which was pertaining to approaches to study Indian politics, and it consisted of 3 units. The unit 1 was pertaining to the liberal approach to study Indian politics, and the unit 2 and 3rd were pertaining to the Marxist and Gandhian approaches, respectively. The second block of the syllabus also we have finished. The second block was pertaining to the Indian Constitution, and it included 3 units. The 4th unit was pertaining to basic features of the Indian Constitution. So the 4th unit was pertaining to historical underpinnings, evolution, features, amendments, significant provisions, and basic structure of the Constitution. That we have done. Unit 5 was pertaining to fundamental rights. We have discussed that. Unit 6 was pertaining to directive principles of state policy and fundamental duties. That also we have discussed in the previous class. And in the previous class, we had started the 3rd block, which consists of 3 units. The 3rd block is pertaining to institutions. So it consists of 3 units, Unit 7, 8, and 9. Unit 7 is pertaining to the legislature that we had discussed in the previous class. And in today's class, we are going to discuss 2 units. That is the executive and the judiciary. So let us begin our class with the 8th unit, that is the executive. So we all know that the executive power of the government of India is vested in the President of India, who is both the formal head of state as well as the symbol of the nation. So Article 52 of the Constitution, it clearly says that there shall be a President of India. And Article 53 of the Constitution, it clearly says of the Constitution of India, Article 53 of the Constitution of India, it says that the executive power of the Union, it shall be vested in the President of India. And the second clause of Article 53, it clearly says that the President of India shall also be the supreme commander of the armed forces. So Article 52, it says that there shall be a President of India, and Article 53, it says that the executive power of the Union shall reside or shall rest in the President, and Article 53 clause 2, it says that the President of India shall be the supreme commander of the armed forces of India. Then Article 54 of the Constitution, it talks about the election of the President. That after every 5 years, the President's term shall expire and there shall be election for the President. And it also mentions the electoral college of the President. So Article 55, it talks about the manner of election of the President, and it talks about the electoral college. So the electoral college which shall elect the President of India, it shall consist of all the member of parliaments of both the houses of the Lok Sabha as well as the Rajya Sabha, as well as the elected members of the state legislative assemblies. So the MLAs, the member of legislative assemblies, the elected ones, those who are member of the Vidhan Sabha, and not the members of the Vidhan Parishad. So the electoral college of the that would elect the President of India, it is mentioned in Article 55. It would consist of the members of the Lok Sabha and the Rajya Sabha. Including the nominated members of the Rajya Sabha as well. And apart from that, it would also include the member of the legislative assemblies of the state and not of the legislative council. So the elected members of the legislative assemblies of the state, that is the Vidhan Parishad, they consist of the electoral college that would elect the president along with the member of Lok Sabha as well as Rajya Sabha. So this is Article 55. Then Article 57, it says that the president, after completing a 5-year term, is eligible for reappointment. So the president can again contest for that post of president. So we have so far in the history of our country, we have had only one president who has completed 2 consecutive terms. That is Dr. Rajendra Prasad, the first president of India. He has been so far the only president to have completed 2 terms. Otherwise, no other president of India has completed 2 consecutive terms or 10 years. So that is Article 57. And Article 58, it talks about the qualifications to be the president of India. So in order to be the president of India, a person must be 35 years or above. So the age of that person, in order to be eligible to be the president of India, must be 35 years or above in age, and must be a citizen of India and must be of sound mind. So that is Article 58, which talks about the qualifications for being president of India. And Article 59, it talks about the conditions of office. The conditions of office of the president of India. So a person who becomes a president of India shall not hold any offices of profit, should not be holding any offices of profit. So that is clearly mentioned in Article 59, which is regarding the conditions of office of the president of India. So a person who wants to become the president of India shall not hold any office of profit, and also should not be a member of either the Union Parliament or state legislature. If that person is in case member of either the Union Parliament or the state legislature, then that person has to give resignation from that post. Only then that person can become the president of India. It is given clearly in Article 59 of the Constitution of India. Then we have Article 60, which is pertaining to the president. It talks about the oath of the president. Basically, it is the third schedule. So it is basically the third schedule of the Constitution. It talks about the oath of the president of India. And Article 56, it talks about the term of office. The term of office of the president of India is mentioned in Article 56. So the president of India shall hold office for 5 years from the date of appointment. So the term of office of the president of India is 5 years from the date of appointment, and after 5 years the president of India is eligible to seek reappointment, which is given in Article 57. And the president of India is considered the first citizen of India. And in our country, the president of India is the head of the executive, is the nominal head of the executive. So you can say the president of India is the president of India is the de jure head of executive. The de facto head of executive is the Prime Minister of India. The de facto power lies in the Prime Minister of India, but the president is the nominal head of executive. So the de jure head of executive and not the de facto head of executive. The de facto power, the de facto head of the executive is the Prime Minister, and the president is the de jure or nominal head of the executive, and the president is also the first citizen of the country. So this our constitutional apparatus, the executive apparatus in our country, it is modeled after the United Kingdom. However, there is a major difference. In the United Kingdom, the head of the executive or the head of the state is the king or the queen, who is a hereditary monarch. So, however, in our country, we do not have a hereditary head of state. Rather, the president of India is an elected head of state. So, Article 56, it mentions the term of office of the president of India, which is 5 years. Article 57 says that after 5 years, the president of India is eligible to seek reappointment. And Article 58, it mentions the qualifications for the president or office of the president of India. So a person must be at least 35 years or above in age, and a person must be citizen of India and must be of sound mind to be the president. Then Article 55, it talks about the manner of election of the President of India, including the Electoral College. And Article 54 talks about the election of the President of India. Article 53, it says that the executive power of the Union shall rest in the President of India. And Article 53, clause 2, it says that the President of India shall be the Supreme Commander of the Armed Forces. And Article 52, it says that there shall be a President of India. So we have discussed Article 59 as well, which is about regarding the conditions of office of the President of India. So a person, in order to become a President of India, shall not hold any office of profit and shall not be a member of either House of Parliament or state legislature. And if that person is a member, then of either House of the Parliament or of the state legislatures, or holds some office of profit, then that person has to resign from that. So Article 60 of the Constitution, it talks about the oath of the President of India, which is given in the third schedule. Article 61, it talks about the impeachment of the President of India. So the President of India can be impeached, and the impeachment of the President, it can be done by both the houses of the Parliament. So there would be a joint sitting of both the houses of the Parliament, and in this case, the Parliament has quasi-judicial powers. The Parliament has quasi-judicial powers in this case, and the President would have to appear before both the houses of the Parliament, and if it's passed by a 2/3 majority by both the houses, joint sitting of both the houses, then the President shall stand to be impeached. However, in our history so far, no such presidential impeachment has ever occurred. Even the process has not yet been initiated in the history of our country. So the provision is there in Article 61 of the Constitution for the impeachment of the President, but no such impeachment has ever occurred in the history of our nation. So Article 62, it says that the procedure for the election of the next president shall be over before the term of the sitting president expires. So before the term of the sitting president expires, the procedure for electing the new president, that procedure must be over, and the person who will be the next president will hold office from the date of appointment. So this is given in Article 62. Then we have the Vice President of India. So Article 63, it says that there shall be a Vice President of India. And Article 64, it says that the Vice President of India shall be the ex officio chairman of the Rajya Sabha or the Council of States. So Article 63, it says that there shall be a Vice President of India, and Article 64, it says that the Vice President of India shall be a member, or shall be the ex officio chairman of the Rajya Sabha or the Council of States. And regarding the president, so we discussed in Article 56, the term of office of the president is given. So in case the president wants to resign before the 5-year term is over, no such president in our country has done that. In case the president wants to resign before his or her term of office is over, then the president has to resign, has to address that resignation to the Vice President of India, and also has to send a copy of that to the Lok Sabha Speaker. So Article 64, it says that the Vice President of India shall be the ex officio chairman of the Rajya Sabha. It is also mentioned in Article 89, Clause 2, that the Vice President of India shall be the ex officio chairman of the Rajya Sabha or the Council of State. Article 65, it says that in case the president is absent or is because of poor health, is not able to discharge the duty of his offices, then the vice president shall take over the role of the president. In case of sickness, death, or absence of the president, the vice president of India shall discharge the duties of the president of India. And Article 66 of the Constitution, it talks about the election of the Vice President of India. So, the Vice President of India shall be elected by the Vice President of India shall be elected by an electoral college consisting of the members of Lok Sabha as well as Rajya Sabha. So the elected members and not the nominated members. So the nominated members of the Rajya Sabha, they are not eligible to vote for the vice presidential election. So the electoral college for the vice presidential election, it consists of only the elected members of the Lok Sabha and the Rajya Sabha. So it is much smaller than that of the president, because in case of the president, it includes also the members of the legislative assemblies also of all the 28 states. But in case of vice president, the electoral college, it consists only of the elected members of Lok Sabha and Rajya Sabha. And and that election, it takes place through a single transferable vote through a ballot, and proportional representation through a single transferable vote. And earlier what used to happen was that the vice president was elected by a joint sitting of both the houses of parliament. However, through the 11th amendment, Constitutional Amendment Act, this provision was done away with. So Article 67, it talks about the term of office of the Vice President of India. So the Vice President of India shall hold office for 5 years. The Vice President of India shall hold office for a term of 5 years. And Article 67, Clause 2, it mentions that it mentions the procedure of the removal of the Vice President of India. So in order for a Vice President of India to be removed, a resolution has to be passed first by the Rajya Sabha by a 2/3 majority, and then that resolution has to be seconded by the Lok Sabha as well. Only then the Vice President can be removed. So this is given in Article 67, which talks about the term of office of the Vice President, which is 5 years. And Article 68, it talks about Article 68. It basically says that the person who is to be elected vice president, the next vice president, the election procedure of the next vice president of India should be over before the term of the sitting vice president is completed. So before the 5 years, before the term of the sitting vice president is completed, the election procedure for the next vice president shall be over, shall be done with. That is mentioned in Article 68. And Article 69, it talks about the oath of the Vice President of India, which is also given in the 3rd schedule. And Article 70, it talks about the contingency power of the president. So the Union Parliament, it can by an amendment, by passing a law, it can increase the power of the president. So the ancillary power of the president. Article 70 talks about the ancillary powers of the president. So the powers of the president can be increased by the Union Parliament as well. Then Article 71, it talks about matters regarding the election of the Vice President and President of India. So any dispute regarding the election of the Vice President or President of India shall be resolved by the Supreme Court of India, according to Article 71. And Article 72, it talks about the pardoning power of the President of India. The President of India has the power to grant pardons, respites, reprieves, and has the power to commute death sentences, and has the power to pardon death sentences or provide reprieves or respites to convicts. And Article 73, it talks about the extent of the power, executive power of the Union. So the executive power of the Union, it extends to all subjects which are mentioned in the union list and the concurrent list according to Article 73, which talks about the extent of the executive power of the union. Then we have as part of the executive, we have the Prime Minister of India. 4. It says that there shall be a council of ministers headed by the Prime Minister, and the President shall administer oath to the Prime Minister of India. So there shall be a council of ministers headed by the Prime Minister, and the Article 74, it says, the clause 2 of Article 74, it says that the President shall work on the advice of the Council of Ministers. So the President cannot take decisions arbitrarily. Rather, the President has to take decisions, has to work as per the advice of the Council of Ministers headed by during the emergency. It says that whether and what advice has been rendered by the Council of Ministers to the President of India cannot be called into question in any court, cannot be inquired into in any court. So it is immune from judicial review. Whether and what advice has been rendered to the President of India by the Council of Ministers. This is given in Article 74, Clause 3. Then Article 75, it talks about other provisions as to ministers. So Article 75, it says that other ministers apart from the Prime Minister, they also shall take oath. They shall also be administered oath as per the advice of the Prime Minister. So the Prime Minister will select his or her Council of Ministers, and they shall be administered oath by the President. And Article 75, Clause 2 says that the ministers, they hold office during the pleasure of the President. And Article 75, Clause 3, which can be referred to as the cornerstone of our parliamentary democracy. Article 75, Clause 3, which can be called the cornerstone of our democracy. So Article 75, Clause 3, it says that the Council of Ministers headed by the Prime Minister, they have collective responsibility towards the House of the people. So they hold office only as long as they enjoy the confidence of the House of the people. The moment they lose the confidence of the House of the people, they shall have to resign. So the House of the people of the Lok Sabha, they have the power to pass the no confidence motion against the Council of Ministers. And if the no confidence motion gets passed against the Council of Ministers, then the Council of Ministers shall have to resign. And if the Council of Ministers resign, then the government itself falls, and the Prime Minister, who is the head of the Council of Ministers, shall have to resign. And in this case, the role of the President becomes very important. So if a sitting government loses its majority and a no confidence motion against it is successfully passed, then the President can exercise his or her discretionary powers. So in this case, it is up to the President whether to call another person, another leader, and whether to ask that leader to form the government, or whether to call for fresh elections. If the President is of the opinion that no party has sufficient majority, can muster majority to form a stable government, and so in that case, the President can decide to dissolve the House as well. So there have been numerous instances. For example, in 1991, when the government led by Chandrasekhar, Prime Minister Chandrasekhar, it lost its majority in the House of the People after the Congress party withdrew its support. Then President of India, R. Venkatraman, called for fresh elections. So there are many such examples. And there are examples when a Prime Minister was not able to prove his majority, then the President did not call for fresh elections, rather invited another leader to form the government. For example, when in 1996, after 13 days in power, former Prime Minister Shri Atal Bihari Vajpayee ji was not able to prove his majority, then the President of India, Shankar Dayal Sharma, did not dissolve the House, did not call for dissolution of the House. Rather, he invited H.D. Devegowda of the United Front to form the next government, which also lasted for only 11 months. So the discretionary power of the President of India, it comes into play when the government loses its majority in the House, and Article 75 Clause 3 clearly says that the Council of Ministers, they have a collective responsibility towards the House of the people, and they stay in power only as long as they have enjoyed the confidence of the House of the people. The moment they lose confidence, if a no confidence motion is passed against them, or if a government is not able to pass its budget, then also it is considered that the government does not have the majority or the confidence of the House. So Article 75 Clause 3 can be referred to as the cornerstone of parliamentary democracy of India. Then we have Article 76, which talks about the Attorney General of India. The Attorney General is the first law officer of the government of India, and the Attorney General is mentioned in the Article 100 and is in Article 76. And we in the same way, for states also we have Advocate General. So every state has one Advocate General, which is mentioned in Article 165, who is the first law officer of that state or province. Then Article 77, it talks about the contingency powers of the Union. Then Article 78, it says that it is the duty of the Prime Minister of India to furnish information regarding the meetings of the cabinet. So the decisions that are taken in the cabinet meetings, the Prime Minister has to convey them, has to furnish the informations regarding them to the President of India, because it is the duty of the Prime Minister. And it is mentioned in Article 78 of the Constitution. Also, there are other provisions as well. For example, Article 88 of the Constitution, it says that the Attorney General of India, as well as the ministers, they have the right to speak in both houses of the Parliament, irrespective of the house of which they are members. So Attorney General is not member of any house of the Parliament, but the ministers, they are member of either house of the Parliament. Either they are members of the Lok Sabha or they are members of the Rajya Sabha. So, but the ministers and the Attorney General, they have the power to speak in both the houses of the Parliament, but they cannot vote in both the houses. So the ministers, they can vote in only that house of which they are members, and the Attorney General cannot vote but can speak in both the houses, and they cannot be a member of parliamentary committees. So this is very clearly elucidated in Article 88 of the Constitution of India. Then we have Article 111, a very important article regarding the President of India. So regarding the President of India, there is a very important article, that is Article 111, which says that if a bill is passed by both houses of the Parliament and it goes to the President for his or her assent, then we are talking about an ordinary bill and not a money bill. So if a bill is passed by both the houses of the Parliament, Lok Sabha and Rajya Sabha, by majority, and if it goes to the President of India for his or her assent, then the President of India can reject it, can send it back only once. If after sending it back, if it is again passed by both the houses of the Parliament, then the President of India has to give her assent to the bill, cannot deny her assent. However, in case of an ordinary bill, there is no time limit that is mentioned. So if a bill is passed once by both the houses and it goes to the Parliament and it goes to the President, and the President sends it back for reconsideration, and again it is passed by both houses of the Parliament, then the president cannot deny her assent. However, the Constitution of India, it does not specify any time limit within which the president has to give her assent to that bill. We are talking about an ordinary bill. So, in this case, the president can exercise her pocket veto. So, in this case, the president can exercise his or her pocket veto, and this was done by President Gyani Zail Singh, the president of India, the former president of India, Gyani Zail Singh. He exercised his pocket veto in when the Indian Postal Bill was passed by the then Rajiv Gandhi-led Congress government, and the president did not give his recognition, and again and sent it back for reconsideration. Then again it was passed. However, President Gyani Zail Singh did not give assent to that bill, and so there is no time limit which is specified within which the president of India has to give assent to a bill if it is passed, if it is sent back for reconsideration. In case of the US president, there is a time limit of 14 days which has been given in the Constitution of the United States. But in our Constitution, in case of ordinary bills, there is no time limit which has been specified. So the president of India can exercise her pocket veto in this case. So I gave you the example of the Indian Postal Bill and how the then president of India, Gyani Zail Singh, he exercised his pocket veto and did not give assent to the Indian Postal Bill, which was passed by the Rajiv Gandhi-led Congress government. So Article 111, this provision that if an ordinary bill is passed for the second time and sent for the president's assent, it cannot be denied by the president. It was inserted by the 42nd Amendment Act of 1976. Earlier, this provision was not there. So, also the president has ordinance making powers. According to Article 123, if the Lok Sabha or the Rajya Sabha is not in session, if the parliament is not in session, and the government wants to pass a law, wants to enact a law, then it can take the ordinance route. It can take the route of the ordinance. And however, the life of the ordinance is 6 weeks. So 6 weeks from the commencement of the House, it has to be passed within 6 weeks. Otherwise, the ordinance lapses. So it is through the President of India that the executive, the Council of Ministers, they exercise their ordinance making power. And the governor of states, they also have ordinance making power under Article 213. Under Article 123, the President of India has ordinance making power. However, on what basis the President of India was satisfied that an ordinance should be enacted to enact a law, an ordinance should be brought in to enact a law, the basis of his or her satisfaction is now it is now under the purview of judicial review. So in the Cooper case in 1980, the R.C. Cooper case, the Supreme Court, it said that the satisfaction of the president that an ordinance was necessary to be brought in order to enact a law, that satisfaction of the president can be questioned in the court. That on what grounds was the president satisfied that the ordinance route is to be taken to bring a law, to enact a law. So that ground, that satisfaction, that ground on which the president was satisfied that an ordinance should be enacted, that can be called into question in the court of law. In the Cooper case, the Supreme Court said it. And also in the DC Wadhwa case, the judiciary, it clearly mentioned in the DC Wadhwa case that the ordinance making power of the president, it cannot be misused by the executive, by the political executive. It cannot be misused, and ordinance, it should be enacted only in exceptional and rare circumstances. So in the state of Bihar, one ordinance was being enacted for many years, and the same ordinance is reenacted again and again. So that practice has to stop. The Supreme Court made it clear in the DC Wadhwa versus State of Bihar case. So not only ordinance is an exceptional provision it has to be exercised only in exceptional cases, but also the grounds on which the president was satisfied that that the ordinance route is necessary to enact a law. That ground also now under the purview of the judicial review, which is a basic structure of the constitution. So, Article 143, it also says that Article 143, it also says that the President of India can uh, take advice of the Supreme Court as well in some cases. In some cases, the President of India, according to Article 143, can take the advice of the Supreme Court of India as well. Then we have Article 105, which talks about decision as to disqualifications. So, if the members of the Lok Sabha are disqualified, this is given in Article 103. So, Article 103, which is regarding decisions regarding disqualification of members of the Parliament, then the final decision is to be taken by the President of India in consultation with the Election Commission. So after the decision of the Speaker or the Chairman of the House, that member can appeal to the President of India, the disqualified member, and the President of India shall produce the final decision after consulting the Election Commission of India. And also Article 361, it says that the President of India and the governors of state, they are immune from any sort of legal proceedings. So they have immunity, legal immunity. They are immune from any sort of criminal or legal or civil proceedings while they are in office. This is a very controversial provision, and it is given in Article 361 of the Constitution, which says that the President of India and the Governor of States, they are immune from any sort of legal or criminal proceedings while they are in office, while they hold office. And as I have just discussed, that the President is not a member of either House of Parliament. However, Article 79, it says that the President is an integral part of the Union Parliament. And Article 86, it says that the President can address the House and can send messages to the House of Parliament, both the Houses of Parliament. The President can address the House, both the Houses of Parliament, according to Article 86, and can send messages also to both the Houses of the Parliament. And Article 87, it says that at the beginning of every session of the Parliament, the President, at the beginning of the first session, that is the budget session of the Parliament, the President shall give an address to the House. So the budget session, which is the first session of the Parliament every year, it shall begin with the presidential address. And also the President nominates 12 members to the Rajya Sabha. So 12 members are nominated by the President of India to the Council of States or the Rajya Sabha. And the President of India appoints the chiefs of the Army, Navy and Air Force, and also has the power to declare war and conclude peace. But these powers have to be exercised by him subject to the ratification of the Parliament. And also if the Union Parliament, it wants to declare national emergency as per Article 352, then also the President's decision is the final. And if the Union Parliament wants to impose, if the Union government wants to impose President's rule in a specific state as per Article 356, then also the President's assent is necessary. However, that decision of imposing President's rule, it can be called into question in the judiciary. It is under the purview of judicial review as per the S.R. Bommai versus Union of India judgment of 1994. And in order for any money bills to be introduced in the Parliament, they have to first obtain the recommendation of the President. Hence, because the money bills, they are presented in the Parliament in the Lok Sabha only, with the assent of the President only. hence they cannot be rejected by the president. And also constitutional amendment bills also, they also cannot be rejected, or they also cannot be delayed. Assent to those bills, that is money bills and constitutional amendment bills, cannot be delayed or rejected by the president of India. And also such prior recommendation which is required in the case of money bills is also necessary for introducing bills regarding the formation of new states, alteration of areas, boundaries, and names of existing states. So all these provisions that are given in Article 3 of the Constitution, that the Union government has the power to form new states, to alter areas of existing states, areas or boundaries or names of existing states. So all these powers, they rest in the Union government, in the Union Parliament, but they can only be done with the prior recommendation of the President of India. So we have discussed the President and the Prime Minister of India, that we have discussed so far, and also we have discussed the Vice President of India, and also we have discussed the principle of collective responsibility enshrined in Article 75, Clause 3 of the government. And each minister accepts and agrees to share responsibility for all decisions of the cabinet under this collective responsibility. And if any member of the Council of Ministers is unable to support the government policy in Parliament or the country at large, then that member is morally bound to resign from the Council of Ministers. So, if a Council of Ministers is formed as a result of a coalition of various political parties, then a minimum common program, it becomes essential for maintaining the solidarity of the ministry, and the various political parties forming the coalition government have to stand behind that program. So that we have discussed the cabinet and the parliament, that the very existence and survival of the prime minister and council of ministers depends upon the support they receive in the parliament. So unlike the US president, who is not dependent, whose survival is not dependent on the US Congress, in our which the US Congress, which consists of the Senate and the House of Representatives, the two houses, Senate being the upper house and House of Representatives being the lower house in the United States. However, the survival of the President of the United States is not dependent on the Congress of the President States, because there it is in the United States they have a presidential form of government. However, in our country we have a parliamentary form of government, Westministerial type of parliamentary form of government, and the very existence and survival of the Prime Minister and Council of Ministers, it depends upon the support that they receive in the Parliament. So we have also discussed Article 78, which says that it is the duty of the Prime Minister to furnish information relating to administration of affairs of unions and proposals for legislation, and also to communicate to the President all decisions of the Council of Ministers relating to the administration of affairs of the union and proposals for legislation. So the ninth unit, we have done the eighth unit, which is executive. So the ninth unit is pertaining to the judiciary. So in Article 124, the Supreme Court of India is mentioned. Article 124, it talks about the Supreme Court of India and the powers and functions of the Supreme Court of India. So the Supreme Court of India is the highest court in our country, is the highest court of appeal. And we have a unified judiciary. Unlike the United States, we have a unified judiciary with the Supreme Court at the top, and all other courts, that is the high courts of the state and the subordinate and lower courts, the district courts and all, they are beneath. So there is a hierarchy. We have a unified system of judiciary with the Supreme Court at the top. And Article 124, it says that there should be a Supreme Court of India, and it talks about the powers and functions of the Supreme Court. Article 125, it talks about the salaries and allowances of the Supreme Court, of the judges of the Supreme Court. Then we have Article 126 of the Constitution of India, which talks about the Article 126, it talks about the acting Chief Justice. Article 126, it talks about the acting Chief Justice. So in case the Chief Justice is not available, then another judge as per seniority can act as the Chief Justice. Article 127 of the Constitution of India, it talks about it talks about ad hoc judges. It talks about ad hoc judges. And Article 128, it says that retired judges, they also can be called into service by the Supreme Court as per Article 128. Article 129, regarding the judiciary in the Constitution of India, it says that the Supreme Court is a court of record and has the power to punish for its contempt. And Article 130, it says that the seat of the Supreme Court, it shall be in New Delhi. And Article 131, it talks about the original jurisdiction of the Supreme Court. And Article 132, it talks about the criminal jurisdiction of the it talks about the appellate jurisdiction of the Supreme Court. So Article 131 talks about the original jurisdiction of the Supreme Court, and Article 132, it talks about the appellate jurisdiction of the Supreme Court. Article 133 talks about the appellate jurisdiction of the Supreme Court in civil matters, and Article 134, it talks about the appellate jurisdiction of the Supreme Court from high courts in criminal matters. Then we have Article 135, which says that the Federal Court of India, which was established by the Government of India Act 1935, that Federal Court of India shall be now known as the Supreme Court of India. So in India, the Britishers, they, through the Government of India Act 1935, established the Federal Court of India in New Delhi in 1935, which came to be known as the Supreme Court of India post-independence. However, before independence, the Supreme Court of India was not the highest court of appeal. Rather, it was the Privy Council of the Emperor, of the British Emperor, which was the Privy Council of the British Emperor. That was the highest court of appeal. But now in our country, the Supreme Court of India is the highest court of appeal. So Article 135, it says that the Federal Court shall be known as the Supreme Court. And Article 136, it talks about special leave petition. So special leave petition can also be filed in the Supreme Court of India. Article 137, it says that the Supreme Court of India can review its judgments. So a judgment which is once pronounced by the Supreme Court of India is not permanent in nature. It can be reviewed and modified by the Supreme Court. For example, the Supreme Court has modified its judgment regarding fundamental rights and directive principles. So, for example, in the Shankari Prasad versus Union of India case in 1951, the Supreme Court had said that fundamental rights, they can be amended to implement the directive principles, and they do not violate Article 13, right? So fundamental rights, they can be amended by the Parliament. Fundamental rights, they can be amended by the Parliament to implement the directive principles. That is what the Supreme Court had said in Shankari Prasad versus Union of India case of 1951, when the Government of India was passing land reform laws, and many people, they were apprehensive that that was violating their fundamental right to property, which was then a fundamental right under Article 19, Clause 1, Subclause F. However, the Supreme Court, it took a complete U-turn. It changed its judgment. It reviewed its own judgment, and it brought in the doctrine of prospective overruling in 1968, when in the Golaknath case, Golaknath versus IC Golaknath versus State of Punjab case in 1968, the Supreme Court said that none of the fundamental rights can be amended. So the Supreme Court in the IC Golaknath case, it said that the fundamental rights are sacrosanct and they cannot be amended. And the Supreme Court, it reviewed its own judgment and it changed its judgment to say that fundamental rights are sacrosanct. And in response to that, the Parliament, it passed the 24th Amendment, which said that in order to implement the directive principles enshrined in Article 38 and 39, the fundamental rights can be amended, and such amendment cannot be called into question in any court of law. This is what the Parliament passed through the 24th Amendment Act. And the Supreme Court responded to this in the Kesavanand Bharati versus Union of India case of 1973, when it propounded the judicial doctrine of basic structure, in which it said that the judicial review is a part of the basic structure of the constitution. And however, fundamental rights, it again changed its decision, which it had given in IC Golaknath case of 1968, and it said that fundamental rights can be amended, but it should not affect the basic structure of the constitution. So it eliminated some aspects, features of the constitution, and termed them as the basics, categorized them as the basic structure of the constitution. For example, judicial review is a basic structure of the constitution according to the Supreme Court. So the Supreme Court, it has reviewed its own decision many times. For example, regarding fundamental rights, and in the Minerva Mills versus Union of India case, the Supreme Court says that harmony and balance between the fundamental rights and directive principles, they are an essential feature of the basic structure of the Constitution of India. This is what the Supreme Court said in the Minerva Mills case. Also in the IR Coelho case of 2009, the Supreme Court said that those laws which have been inserted in the ninth schedule to protect them from judicial review, they cannot be cannot be called into question that they are affecting the fundamental rights of the citizens, but they can be called into question in the judiciary on the grounds that they are affecting the basic structure of the Constitution of India. So we have seen that the Supreme Court of India, it has reviewed its own judgments on multiple occasions, and it has given rise to multiple judicial doctrines as well. That is the doctrine of prospective overruling, the doctrine of basic structure of the Constitution. And during the emergency, we saw that the judiciary, it became subdued by the executive. And the ADM Jabalpur versus Shivkant Shukla case, which is considered a blot on the judiciary. In that, the judiciary, it basically gave its assent to the excesses that were being to the curbs that were being imposed on fundamental rights. However, later on we see post independence that the judiciary, it started engaging in what has been called judicial activism. Judges like Justice Bhagwati, Justice P.N. Bhagwati, and the like, they started engaging in judicial activism, and through something called the public interest litigation or the social action litigation. So this came into being in the Husainara Khatun versus State of Bihar case, which was regarding the right of under trials in the state of Bihar. From there on, the Supreme Court, it started engaging in judicial activism. So to fill in the gaps left by the executive, the judiciary has started engaging in judicial activism, has started asserting itself through the 4 judges' cases that we observed. The first judge's case, the second, the third, and the 4th judge's case. The Supreme Court, it in a way freed itself from political interference. And in our judiciary, we have the collegium system. That is, the judges, they appoint themselves. And there are many pros and cons of this system as well. And the Supreme Court has been engaging in public interest litigation or social interest through public interest litigation. That is, the Supreme Court has set aside the principle of locus standi, that in order to appeal to the court regarding any matter, that person's own fundamental rights should not be affected, but a person can file a writ petition in the court on behalf of any other group of persons who are not able to do that themselves. And the Supreme Court has also taken initiatives to provide free legal aid under Article 39 Clause A of the Constitution, which was again inserted during the emergency through the 42nd Amendment. And the Supreme Court has indulged in judicial activism, and it has widened the horizon of Article 21, that is right to life and personal liberty, by including many aspects like right to privacy in the case Puttaswamy versus Union of India case 2017, right to a clean environment and clean pollution-free air in the Subhash Kumar versus State of Bihar case 1991, right to health in the Bandhua Mukti Morcha case 1997. So multiple aspects have been included to broaden the horizon of the right to life and personal liberty by the Supreme Court of India. For example, right to livelihood and right to shelter was also included as right to life as a part of its judicial activism by the Supreme Court in 1985, Olga Tellis versus Bombay Municipal Corporation case. And this has led many experts to call for judicial restraint. It says that the Supreme Court is now indulging in judicial overreach and it must exercise judicial restraint. So we have discussed the role of the judiciary in our country. So Article 138, it says that the Union Parliament, it can increase the powers of the Supreme Court, ancillary powers of the Supreme Court. And Article 139, it says that the writ jurisdiction of the Supreme Court can also be increased by the Parliament. Both Article 138, 139 and 140, they say that the powers of the Supreme Court and the writ jurisdiction of the Supreme Court, they can be increased by the Parliament. And Article 141, it basically says that in Article 141, it clearly says that all civil and judicial authorities, they should aid the Supreme Court in its functioning. And Article 142, it says that the Supreme Court, it can punish for its contempt, and it has powers to order to issue instructions for discovery or to produce a person before, to ask a person to be produced before itself. And Article 141, it basically said that all civil and judicial. So Article 144, it says that all civil and judicial authorities should act in aid of the Supreme Court. And Article 141, it says that Supreme Court is the highest court and all courts, they operate under the Supreme Court. And all courts with judicial courts within the territory of India, they operate under the Supreme Court. And Article 142, it says that the Supreme Court has the power to issue summons and in regarding discovery of evidence, and has the power to ask people to appear before itself, and also has the power to punish for contempt of itself. So, thank you so much. We have completed the 8th and the 9th unit in today's class. So, thank you so much. Namaste.